Bill 60 just passed in Ontario, and it's about to change the way every landlord and tenant handles disputes, evictions, and Landlord and Tenant Board hearings. Whether you rent out your basement or manage multiple properties, or you're a tenant trying to protect your rights, this affects you. And as private investigators, we work with both sides, landlords and tenants, to gather the facts you need for your LTB case. Today, I'm breaking down what Bill 60 actually means, without legal jargon, and how you can protect yourselves under these new rules. Section 1, what is Bill 60? On November 24th, 2025, Ontario passed Bill 60, the Fighting Delays, Building Faster Act. One of its biggest impacts is on the Residential Tenancies Act and how the Landlord and Tenant Board process eviction and termination cases. Why the changes? Because Ontario wants faster housing, faster procedures, and fewer LTB delays. Section 2, the biggest changes you need to know. Number 1, only LTB-approved forms can be used. No more homemade end forms or letters. If you're ending a tenancy or being evicted, it must be on approved LTB form, period. Number 2, non-payment eviction notices can now be issued after 7 days. Before, landlords had to wait 14 days. Now, they can start the process at day 7. This is a big shift. It cuts the waiting time in half and speeds up non-payment cases substantially. Number 3, personal use eviction require 120 days notice, but no compensation. Previously, landlords had to give 1 month's rent or provide a comparable unit. That requirement is gone. This is one of the biggest wins for landlords in over a decade, but a challenge for tenants. Number 4, tenants must pay 50% of arrears to raise issues at the hearing. This is huge. If a tenant is being evicted for non-payment and they want to raise concerns like maintenance, they must first pay half their rent arrears up front. It's designed to prevent delay tactics and keep cases moving. Number 5, you must request an LTB review within 15 days, not 30. If you want the board to reconsider a decision, the window just shrank in half. If you miss it, you're out of luck. Section 3, what this means for landlords. Landlords are about to see a much smoother, faster process. Faster non-payment procedures, less financial loss while waiting, no compensation required for personal use evictions, fewer situations where tenants can delay a hearing, tighter rules on reviews and appeals. It's a major rebalancing of the system for landlords. Section 4, what this means for tenants. For tenants, the biggest change is the new 50% arrears payment rule. If you're behind on rent and want to raise issues at the hearing, you must pay half of what's owed. This doesn't take away your rights. Maintenance issues, harassment claims, and disputes can still be brought forward, but you'll need to meet certain requirements first. This change is meant to ensure the board isn't overwhelmed by cases where rent was withheld without evidence. Section 5, where private investigators come in. At the Smith Investigation Agency, we assist both landlords and tenants. We're neutral. We're fact gatherers. Our role is to uncover truth, not take sides. How we help landlords? Surveillance to confirm unauthorized occupants, evidence of subletting or short-term rental misuse, documentation of property damage, verification of tenant behavior, locates for tenants who have disappeared owing rent, and of course, how we help tenants. We gather evidence of harassment or intimidation, documenting unsafe or unmaintained living conditions, proving landlord entry without proper notice, neighborhood canvassing for witnesses, digital investigations into online ads, past listings, or rental activity. Under Bill 60, evidence matters more than ever. Whether you're a landlord or a tenant, you need documentation, timestamps, photos, videos, timelines, and unbiased third-party verification. That's exactly what licensed private investigators are trained to do. Why this matters now? With shorter timelines and stricter rules, you have less time to prepare your case. The board has less time for delays, and the burden is on you to bring solid evidence. The days of showing up empty-handed at an LTB hearing are over. Bill 60 is changing Ontario's rental landscape in a big way. Whether you're a landlord protecting your investment or a tenant fighting to be treated fairly, the best thing you can do is be informed and be prepared. If you need help gathering evidence for your LTB matter, reach out to us here at the Smith Investigation Agency. We're Canada's largest female-owned private investigative firm, and we're here to support your case with facts, not bias. Stay prepared, and I'll see you in the next video.